Good afternoon, everyone, and I'm delighted to be welcoming you to this second in our discussions in the dispute resolution series. Again, we're delighted to be partnering with the Chartered Institute of Arbitrators Ireland and to be kindly supported by the National Forum for the Enhancement of Teaching and Learning in Higher Education. Without further ado, I'm going to pass you over to the chair of today's session, Ms Meg Burke, BL, who's going to introduce today's speaker. Thank you.
Thank you, Mary, for such a lovely introduction. I'm delighted to have been invited to chair today's webinar on alternative dispute resolution. As the Chartered Institute of Arbitrators is always delighted to partner with UCC in bringing this series of events to you. And I think for anyone who managed to tune in this time last week, you'll agree that the topics are always very relevant and informative. And I think today shall be no different. There's a Q&A function at the screen also for you to submit any questions that you may have for today's speaker. Today's speaker is Mr. John Gaffney, and his paper is entitled Perspectives on a Changing Arbitration Landscape. John is a fellow UCC alumni and, more importantly, a Cork man. He now practices, though, from much sunnier climes in Abu Dhabi in the firm of Tamimi Co. John has an extremely accomplished CV as an international arbitration lawyer, and he's admitted as solicitor in both Ireland and England and Wales. He's also listed on the who's who of international commercial arbitration. So without any further ado, I'm going to hand you over to the man himself, Mr. John Gaffney.
Thank you, Meg. And good afternoon, everyone. I hope you can hear me. Greetings from Abu Dhabi. We're enjoying slightly different weather to what you're enjoying back home. It's something of a hackneyed expression of gratitude, but it really is a privilege to have been invited by UCC to share my thoughts with you on this lunchtime webinar, and I hope there will be of some interest. I've been invited to address you on the topic, as Meg said, of perspectives on a changing arbitration landscape. As Meg noted in her introduction, I am an Irish qualified solicitor. Now, having practiced in Ireland previously in Cork and Dublin, I'm now practicing arbitration and international arbitration in the United Arab Emirates, or UAE, based here in Abu Dhabi. In the 20 minutes or so that I'll be addressing you, I'm proposed to give you my perspective on the changing UAE arbitration landscape, with special reference to these unfortunate pandemic times, and then to draw perhaps a lesson or two for Ireland, just to sort of bring it home in terms of its relevance. So if I can start with the United Arab Emirates, or the UAE, as I refer to it. The UAE is unique in that it possesses 3 arbitral jurisdictions in the one country. I'm not sure if any other country does that. You have what we refer to as sort of onshore or mainland UAE, which is composed of 7 emirates. And then you have 2 offshore international financial centers, the Abu Dhabi Global Market, from where I'm speaking today to you, and then in Dubai, the Dubai International Financial Center, or DIFSC. And each of these jurisdictions has its own arbitration law. So in the case of the UAE, you have the Federal Arbitration Law. The ADGM, or Abu Dhabi Global Market, has its own arbitration regulations, and the DIFSC has the DIFSC arbitration law. And I think another interesting aspect is that both the ADGM and the DIFSC are common law islands in the UAE, which is a civil law country. So again, it's quite unique. One can imagine the converse in Ireland of having civil law jurisdictions sitting within what is a common law country. The ADGM regulations were introduced in December 2015. So that was about 2 years after I moved to Abu Dhabi and began practicing here. And at the time, they were, rightly welcomed as one of the most progressive and modern arbitration laws in the Middle East. And at that time, for the purpose of this talk, it's worth remembering or recalling that in 2015, onshore UAE arbitration law was very outdated. It dated back to the early 90s, and it formed part of the Civil Procedure Code, which governs litigation before UAE courts. So you could see in that case that arbitration was pretty much adjunct to litigation. And anyone of my age or older will remember the times when arbitration was perhaps treated the same way in Ireland. When the COVID-19 pandemic hit the UAE, as it did in the entire world, unfortunately, last year, the position of the ADGM Arbitration Regulations as one of the most progressive and modern arbitration laws in the Middle East remained the case, but with one noticeable exception, and that was the use of technology in the conduct of hearings, on which the regulations contain no express provisions in their 2015 form for much of last year. Now, in contrast, the UAE Federal Arbitration Law, which was passed in the meantime in 2018, expressly addresses the use of technology in the conduct of hearings. And just to give you some examples, Article 28 of the UAE Arbitration Law provides that the arbitral tribunal may, unless otherwise agreed by the parties, hold arbitration hearings with the parties. The tribunal may hold arbitration hearings with the parties and deliberate by modern means of communication and electronic technology. The arbitral tribunal shall deliver or communicate the minutes of the hearings to the parties. And Article 33 of the UAE Arbitration Law states that hearings may be held through modern means of communication without the physical presence of the party at the hearing. While Article 35 of the UAE Arbitration Law states the arbitral tribunal may question witnesses, including expert witnesses, through modern means of communications without their physical presence at the hearing. Now, what I read out to you are obviously English translations, as the law is obviously written originally in Arabic. So why are these provisions of such importance in these times? Well, as you will appreciate, the restrictions imposed by the pandemic have curtailed domestic and international travel, as well as in-person meetings, which have customarily been required in both domestic and international arbitration in order for physical, procedural and merits hearings to occur. And so the consequence of this, of the pandemic, has meant that physical hearings have been replaced in many cases by virtual hearings, which are conducted by modern means of technology, such as the Zoom technology, which is being used for the purpose of this webinar, as well as other platforms such as Opus 2. And as Untitled, the UN Commission on International Trade Law, has observed in one of its publications titled Technical Notes on Online Dispute Resolution, online dispute resolution can assist parties in resolving disputes in a simple, fast, flexible, and secure manner without the need for a physical presence at a meeting or hearing. So essentially, modern means of communication can essentially substitute for physical presence at a meeting or hearing. Now, while the ADGM Arbitration Regulations last year recognized modern means of communication, they contain no equivalent provisions to the provisions of the UAE Arbitration Law, which I just mentioned earlier. Now, it can be said that the absence of express provisions in the ADGM regulations did not necessarily mean that technology was not permitted under the regulations to conduct arbitration seated in the ADGM. For instance, Article 32 of the 2015 version of regulations provided that the parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting the proceedings. In the absence of such agreement, the arbitral tribunal may conduct the arbitration in such manner as it considers appropriate. The power conferred upon the arbitral tribunal includes the power to determine the admissibility, relevance, materiality, and weight of any evidence. So, as may be seen, the 2015 version of the regulations conferred on the arbitral tribunal a broad discretion relating to how the arbitration was to be conducted or is to be conducted. And furthermore, the regulations require the arbitral tribunal in all cases to adopt procedures which are suitable to the circumstances of the particular case and which avoid unnecessary delay and expense. So arguably, these provisions would have entitled an arbitral tribunal to conduct an evidentiary hearing using video conferencing or other technological means if it were not possible to meet in person due to the pandemic and the restrictions resulting from it. And this argument, again, was arguably bolstered by Article 33(2) of the 2015 version of the regulations, which entitles the arbitral tribunal to, unless otherwise agreed by the parties, meet at any place it considers appropriate for hearing witnesses, experts, or the parties. Now, having said that, Article 39 of the F.C.I.Arb regulations, as existed then in 2020, or at least the early part of 2020, mandated the arbitral tribunal, subject to any contrary agreement by the parties, to decide whether to hold oral hearings for the presentation of evidence or for oral argument, or whether the proceedings shall be conducted on the basis of documents and other materials. And furthermore, unless the parties had agreed that no hearing shall be held, the arbitral tribunal was required under Section 39 to hold such hearings at an appropriate stage of the proceedings if so requested by a party. As may be seen, the tribunal was obliged to hold an oral hearing subject to any contrary agreement between the parties where one party requested it. And as one leading commentator on international arbitration has noted, a tribunal's refusal to conduct an oral hearing where it has been requested can be a classic instance of denial of a party's opportunity to be heard, leading to the annulment of the resulting arbitration award. So, with that background, and given the lacunae in the arbitration regulations here as compared to the provisions of the UAE arbitration law, which governed arbitration in onshore UAE, such as Abu Dhabi, leaving aside the island on which the ADTM is located, it raised the question of whether the requirement for an oral hearing under Section 39 of the regulations, where requested by one party, would be satisfied by a remote hearing conducted by technological means. Absence of any provision such as Article 172(b)(4) of the Dutch arbitration law, which does expressly provide that the requirement for an oral hearing is satisfied by holding it by video conference and so forth. In contrast, in Sweden, a hearing held by a conference is not regarded as oral within the meaning of the Swedish Arbitration Act. Therefore, if a party requests an oral hearing under that provision, he or she does not have to settle for a video conference. So that posed the risk that a oral hearing, if it were equated with the notion of a physical hearing, could possibly not be recognized as valid were held by modern means of communication. And obviously that's a significant risk, because if an arbitration and all the costs it incurs in terms of legal fees and arbitration fees and administrative fees results in an award which ultimately is annulled on the basis that the oral hearing required or requested by one party was not conducted in accordance with the law, then it ultimately defeats the entire purpose of convening an arbitration. So considering the uncertainty around the possibility of substituting a remote hearing for an oral hearing requested by one party in ADGM arbitrations, one of my colleagues, Malik Nasruddin, and I publicly suggested in an article in 2020 that in any future revisions of the regulations, attention should be given to the permissibility of the use of technology in arbitration seated in the ADGM, thereby as a sort of a timely revision of the arbitration law, allowing to keep pace with contemporaneous global changes. And we said this in the context of a law that was, less than 5 years old. And the slight irony was that in 2015, when my colleague and I also wrote an article welcoming the advent of the ADGM arbitration regulations, we expressed the hope that they would serve as a bellwether for other initiatives, including the then long-awaited enactment of a UAE federal arbitration law. And so the slight irony was that, while the regulations served that function as a sort of bellwether for a UAE arbitration law to follow, by the time we got into mid-pandemic in 2020, the UAE arbitration law was in turn serving as a bellwether for the regulation within the UAE of the use of technology in the conduct of arbitration seated in onshore and offshore UAE. So suddenly sort of the positions were reversed insofar as the issue of technology was concerned. If we then skip forward for the purpose of this talk to December 2020, the ADGM amended its 2015 arbitration regulations following a public consultation process with intention of reflecting international best practice and promoting the use of technology to increase efficiency and to reduce cost. Now, there were quite a number of changes to the regulations, but I'm going to focus for the purpose of this talk on the changes to the regulations which expressly promoted the use of technology to enhance the efficient and expeditious conduct of the arbitration. So under the 2020 amendments, which were introduced, as said, in December of last year, Section 34 promotes the use of technology wherever possible to enhance the efficient and expeditious conduct of ADGM seated arbitrations. Section 34 lists 7 technology-related solutions which a tribunal shall consider in using in appropriate cases, as well as a catch-all category which relates to any other technology under Section 42 of the amended regulation. And Section 43 of the 2015 regulations were also amended to expressly provide for the use of technology in relation to hearings and written proceedings. And so, subject to any country agreement between the parties, that section permits hearings to be conducted by way of video conference, telephone, or other communications if statements, documents, evidence, or other information to be supplied or communicated electronically. And in the consultation paper number 8, which preceded the publication of these amendments, it was stated that the amendments were intended to make the 2015 regulations more contemporary and aligned to international best practice. And so the changes that I've just briefly run through with regard to the use of technology, as well as other changes that the regulations made, certainly enhanced its position as one of the most modern and progressive arbitration laws here in the Middle East. So looking westward, what lessons, does this experience, over 2020 and before hold for Ireland? Well, prior to the pandemic's unwelcome arrival last year, the use of technology was not entirely novel in international arbitration. Parties and arbitrators often used modern means of communication to hold case management conferences, submit party submissions, and so forth in terms of conducting arbitrations. So international arbitration had already shifted into a more technologically oriented culture, albeit for the most part maintaining traditional physical hearings for the merits hearings or evidentiary hearings where witnesses were presented and cross-examined or examined by the tribunal. As I said, as I noted earlier, however, these physical hearings, which have been traditional in arbitration and international arbitration, have become problematic in light of the pandemic and the resultant restrictions. Social distancing measures and travel restrictions have challenged parties and arbitrators to adopt new measures in their proceedings and to adapt to a new reality of conducting arbitrations virtually. So that includes, the need to use video conferencing and other technological means in place of traditional physical hearings. And I think that even when the pandemic passes, I think international arbitration will have been, irrevocably changed with parties using technology more and more and not reverting back to the status quo, not least out of an increased focus on environmentally friendly arbitration and minimizing the impact on the environment through the practice of international arbitration. So as you know better than I do, arbitration in Ireland is governed by the Irish Arbitration Act of 2010, of 2010 rather, 2010. And it's been in force for 11 years this coming June. And, in Ireland, we talk up the Act, and rightly so, as, I'm quoting from one commentary, providing a strong legislative framework for arbitration in Ireland. And that noting that Ireland has sought to use the Arbitration Act of 2010 in conjunction with its reputation as an established common law jurisdiction with highly regarded English-speaking lawyers to develop its potential as a leading arbitral seat. Further, in January 2019, the Irish government announced the introduction of a legal services initiative aimed at promoting Ireland as a global hub for international arbitration. And, that is all true. And with the advent of Brexit, I think Ireland Inc. has stepped up its efforts, to attract arbitrations principally to Dublin. Although I hold out the hope that Cork will also be able to hold and attract arbitrations. There's no reason why not. And obviously, the Irish courts, and particularly the judge in charge of the arbitration list, Justice David Barneville, is doing great work in terms of PR for Ireland, in terms of his approach, his pro-arbitration approach to the resolution of arbitration matters. But for all that excellent PR, and I agree with all that is said in the commentary I quoted, there is no express reference to the use of technology in the 2010 Act. The only reference I could find to electronic communications occurs in Section 7.4 of the Act, and that provides that the requirements in arbitration agreements would be in writing is met by electronic communication if information contained therein is accessible so as to be usable for subsequent reference. Now, it may be said that the 2010 Act and the 2015 version of ADGM regulations are very similar. Both are based on the model law, and the provisions of the 2015 regulations, to which I referred earlier, as an implicit basis for the permissible use of technology, are reflected in the 2010 Act. So, reasons of time, I won't go through them in detail, but for example, Section 32 of the ADGM regulations is contained in Schedule 1, Article 19 of the 2010 Act, which provides, among other things, that failing such agreement, the arbitral tribunal may, subject to provisions of this law, conduct arbitration in such manner as it considers appropriate. Article 33, or Section 33 of the ADGM arbitration regulations are mirrored in Article 20 of Schedule 1 of the 2010 Act. So it may be argued that as far as remote hearings are concerned, the 2010 Act is fit for purpose. However, in the 2010 Act, we also have the equivalent of Section 39 of the 2015 ADGM regulations, which we discussed earlier. And that contains this requirement obliging the tribunal to hold their hearings at an appropriate stage of the proceedings if so requested by a party. So having regard to the experience here in the ADGM, which I have very briefly summarized for you, I would conclude with the following suggestion, and that's that the amendment of the 2010 Act is overdue, not least to clarify the permissibility of the use of technology in conducting hearings and arbitration in Ireland, as well as generally updating the law 11 years on to reflect international best practice. You know, in the wider context, international institutions are updating their rules regularly every few years now. And I think that for Ireland Inc., it wishes to continue to be an attractive place for arbitration and to promote itself, then I think it is time for the 2010 Act to be updated, made fit for purpose, especially in a post-pandemic world where virtual hearings will be commonplace. That concludes my talk, and I'd be happy to address any questions.
John, thank you so much for such an insightful talk. It has been really interesting, I think, to compare the different approaches taken in different jurisdictions in terms of technology and its use in arbitration hearings. I wonder if I might start the questions myself by asking you, in your experience, do you see any potential drawbacks or difficulties encountered with remote hearings?
Thanks, Meg. Well, in my own personal experience, I had a case last year involving US and Saudi parties with an arbitration seated in Dubai. Our client was very keen, the Saudi entity was keen to have a physical hearing, and it became apparent that wasn't going to happen, and the arbitrator wanted to get the case completed. So we did have a virtual hearing, literally in this room, or at least as far as I was concerned, and my colleague in the room from which I'm talking to you now. And so that gave me sort of a practical insight into how they work. I have to say that if the technology works, I think they work reasonably well. But you know, one shouldn't be experimenting, and so you really have to pay attention to the platform that's used and that's reliable and tried and tested. If the technology works, I think it works fine. However, there are two potential drawbacks to come to your question, Meg. And the first is the scope for witnesses being coached. So it's important that if witnesses are in a separate location, so in our case, we had witnesses based in Houston and Daman in Saudi Arabia, that a full 360 view of the room from which they're speaking is available, so that you can see that nobody's in the room with them, coaching them, or they're not checking their phone for answers or the like. And the second is that I think in terms of cross-examination, I think, you know, some lawyers will find that the lack of physical proximity makes it difficult to effectively cross-examine. I just say I conducted a cross-examination. That's one of the reasons I like arbitration. As a solicitor, I can do my own advocacy. And I found it worked well. I thought the dynamic worked well. So that's one of the two caveats that I would see about using arbitration, or three. You need a good technology that's reliable. You need to make sure the witnesses aren't being coached in the background, and it needs to be such that the cross-examination can be effective.
Thanks so much, John. John, another question coming through, and I'm just going to remind the attendees that there is a Q&A function at the end of the screen if you want to submit any questions to John. But I suppose another question that has come through, and I suppose has been my experience as an arbitrator to date, is that there has been some reluctance perhaps amongst parties to preference the remote hearing over the more traditional one. Have you seen a greater appetite to embrace technology since COVID-19 has entered our lives?
I think the appetite for physical hearings remains, but I think as a practical matter, parties have to be realistic. So I had another hearing, another case quite recently, where again, this was interesting because it was an UAE arbitration, so both parties were UAE entities, and yet because we had an international tribunal, and in this case we were represented by QC and Junior, who were leading the advocacy for us in that case, we had to have a virtual hearing. Our QC was terrified, quite rightly, that if he came to the UAE, there could be a lockdown and he could be stuck here for 6 months. And not be able to return to his chambers. So I think parties are sort of resigning themselves to the fact that that virtual hearings are required in those cases, because the alternative is simply to wait for the pandemic to pass. And I don't think arbitrators want that, and I don't think parties want that either. They want to get arbitration is meant to be efficient and quick, and so that's the problem. I do think that in time, as we become all used to this technology, and certainly I can tell you from my practice, I was old school. I used to, read briefs, print it out and so forth. And the pandemic has forced me, in a good way, to go almost entirely online and electronic. So I think that will have an impact and will make people more open to virtual hearings for the future. But it's a bit of a learning curve, and I think that, I'm sure you as a barrister and counsel will have encountered the same in terms of adjusting your skill set for online hearings as opposed to physical hearings, which we've all grown up with.
Thanks, John. Yes, I think it can certainly be difficult to change habits of a lifetime. We're all fond of a paper trail that we leave, particularly those at the bar. I'm conscious of the time and the fact that we've marketed this as a bite-sized lunchtime series and that people may need to go and get their sandwich at this point in time. So I'd like to, first of all, thank John Gaffney for such an insightful talk today. And secondly, to all of the various partners who've made this series of events possible. And of course, to our attendees, even though I can't see you all, I believe there's over 100 people online listening to this talk. So we're delighted to have you here. And just maybe a brief reminder that there is a further and final talk of the series next Thursday, where Mr. Eamon Harrington, our colleague from Cumming Kelleher Tobin, is going to give a talk in relation to mediation during the pandemic, opportunities and challenges. So we hope to see you all online again next week. Thank you all very much, and a great thank you to Dr. Mary Tumblety in UCC for bringing this all together today.